Do Reynolds join us? Obviously not. No. Okay. I declare open this public hearing of the Human Rights Subcommittee of the Joint Standing Committee on Foreign Affairs, Defence and Trade for the inquiry into Australia's efforts to advocate for the worldwide abolition of the death penalty. I'd like to begin by acknowledging that where we meet today has been the meeting place for the Ngunnawal and the Ngambri peoples for thousands of years, and we would like to pay our respects to elders past and present and acknowledge the cultures of any Aboriginal and Torres Strait Islander people that may be with us today. This hearing will be broadcast on the Parliament's website, and the proof and official transcripts of the proceedings will be published on the committee's webpage. I now welcome officials from the Department of Foreign Affairs and Trade to give evidence today. For the Hansard record, would you please state your name and the capacity in which you appear before the committee today?
Thank you very much, Senator. Angela Robinson, First Assistant Secretary of the Multilateral Policy and Human Rights Division. Are you comfortable for me to make a short opening statement?
Sure. In a few moments, Ambassador.
Yes, my name is Ms Bronte Mauls, Ambassador for Human Rights and Assistant Secretary, Human Rights Branch, DFAT.
Thank you to you both. This hearing is a legal proceeding of the Parliament. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to questions and discussion. Thank you, Ms Robinson.
Thank you very much, Senator. Australia's position on the death penalty is clear. We have a firm, long-standing opposition to the death penalty in all circumstances for all people. This belief underpins DFAT's international advocacy on global abolition of the death penalty. Advocating for the abolition of the death penalty is a priority for DFAT officials in Canberra and across our overseas network, whether in retentionist countries or in abolitionist countries. We speak out, we work with partners, we advocate, and we influence. Our goal is for all retentionist countries to abolish the death penalty in law and in practice. We advocate in multilateral, regional, and bilateral settings. We work with partner countries who also oppose the death penalty. And importantly, we work very closely with civil society in Australia and internationally. 144 countries are now abolitionist in law or practice, and Amnesty International has found that the number of countries carrying out executions in 2023 was the lowest on record. This is good news, but DFAT is deeply concerned by reports that the number of executions globally in 2023 was the highest in almost a decade, driven mainly by executions in Iran and possibly China, where exact figures remain unknown. This makes it clear that Australia needs to continue its strong advocacy on abolition of the death penalty. We're concerned by Amnesty International's finding that executions for drug-related offences accounted for at least 44% of global executions in 2023. DFAT officials consistently advocate against the use of the death penalty for drug-related offences. We do not consider this meets the threshold of most serious crimes as defined in the International Covenant on Civil and Political Rights. We are also particularly concerned when minority groups seem at disproportionate risk of the death penalty, including with respect to the LGBTQI community, such as in Uganda and Yemen. DFAT's work on this issue is guided by our strategy for abolition of the death penalty, and this has underpinned DFAT's work. Our strategy was usefully informed by the 2017 report of the Joint Standing Committee on Foreign Affairs, Defence and Trade. This year, DFAT has been working across government to update the strategy to ensure it remains effective, reflects international and legal developments since 2018 when the strategy was launched, and more broadly depicts and guides whole-of-government advocacy for death penalty global abolition. The updated strategy will set out DFAT's bilateral, multilateral, public diplomacy, and consular lines of work. This inquiry is opportune for the update of our strategy. We thought the committee may find it valuable to hear about DFAT's concrete actions. Since July 2022, DFAT officials have advocated for abolition of the death penalty in Australia's bilateral engagements with 73 of 85 retentionist countries globally. Where we did not advocate, say in North Korea, this was generally because we have restrictions on our engagement with that government. When countries make steps forward, we can never claim our advocacy as the only influence, But we've been particularly pleased to see notable recent reforms in Malaysia, abolishing the mandatory death penalty, introducing sentencing discretion, and in Ghana, abolition of the death penalty for ordinary crimes. On Ghana in particular, for several years, our officials worked closely with like-minded diplomats and civil society on the ground to advocate for abolition of the death penalty. Multilateral advocacy is also a key complement to our bilateral engagement. We make particular use of the UN's Human Rights Council's Universal Periodic Review. This mechanism reviews all countries' human rights records every 4.5 years and allows us to make recommendations that they need to respond to. We recommend concrete steps towards abolition for all retentionist countries, except in very rare circumstances, and we've done so in 72 of 85 retentionist countries. We've delivered 5 national statements at the UN's Human Rights Council since 2023, expressing our strong opposition and condemnation of the use of the death penalty, including on the basis of sexual orientation or gender identity, religion, political views, or against children. We lead efforts in the UN General Assembly's Third Committee. Australia co-chaired with Costa Rica the most recent biannual UN General Assembly resolution calling for a global moratorium on executions, and we garnered a record 125 yes votes from member states. We very much look forward to the committee's insights and recommendations on how Australia could further improve its global advocacy on the death penalty, and I can assure the committee that this will remain a central focus for DFAT going forward. Thank you.
Thank you, Ms Robinson. Ambassador, do you have an opening statement?
Thank you. I'll just make some brief remarks in addition to Ms Robinson's comments. Firstly, just broadly in terms of our approach to human rights, there's a couple of principles that I'd emphasise. One is universality, the principle that human rights apply to all people, no matter who you are, no matter where you're born. And of course, when we're advocating for the death penalty, this is a really important principle. Another principle that underpins what we do is self-reflection. So we hope that by bringing a spirit of self-reflection to our human rights engagement internationally, it helps us have more constructive conversation. A key point too is broadly on our human rights engagement is the how we say is important as what we say. So again, in the death penalty context, it's really, really important to find the best means to have the conversations, the entry points, to have the discussions so that they can be as constructive as possible. Broadly, I think the operating environment, though, internationally for working on human rights is sadly, we assess becoming more challenging for all sorts of reasons, geopolitical and other reasons. And one of the consequences or one of the impacts of that is that we are seeing shrinking civil society space in many countries, which makes this work more difficult. But our commitment remains unwavering, of course, but in our work on death penalty abolition advocacy, it makes our work with civil society it requires it to be even more nuanced and carefully thought through, because in many contexts, sadly, it is becoming tougher for civil society to operate. Thank you.
Thank you very much. I might ask Senator de Manon to begin with the questions. Yeah.
Thank you. I was wondering if you could let us know if you know how many Australians and Australian foreign nationals are currently on death row awaiting execution globally, and whether you've got information about whether the numbers have been increasing or decreasing, and what kinds of offences are leading to the death sentences.
I'll invite my colleague to take the floor.
Senator Paula Ganley, First Assistant Secretary, Consular and Crisis Management Division. There are a very small number of Australians who are facing the death penalty overseas. Because the numbers are so small, we don't tend to advertise how many there actually are, because some of them, for welfare reasons, and others have asked for privacy to the point where they don't even want family members to know the situation. So therefore, by giving the exact number or identifying the countries in which they are imprisoned, there is the fear that their welfare is at risk. But I can tell you it's a very small number. I can tell you that the number has been more or less consistent because we do have some successes, and the Prime Minister mentioned the success of the two cases being commuted from death penalty in Vietnam, and we get those commuted only, unfortunately, in other circumstances for Australians to be convicted with a death penalty sentence prevailing.
Mm-hmm. Thank you. And in the event that we do see an Australian in this situation, are they able to access emergency funding for legal assistance if they are unable to support themselves in responding?
Yes, so look, I'll say at the outset, Australia takes very seriously and places a very high priority on any Australian who is arrested on a charge that potentially carries the death penalty. And we have looked at the systems, and they will be tailored depending on the country and the circumstances for which they're being charged. But we have updated all our processes, and our people overseas will, who are our consular officers who are visiting them, will make sure that they are aware of all opportunities available, and that includes funding for Australians who are accused of sentences that may carry the death penalty, and that is a fund that is managed through AGD. We will also, speak to the families about what they need to do to apply for this funding. And in some cases, we will, if necessary, also help facilitate the paperwork to get that through so that they can access the funding.
Thank you. In the noting that you're updating the strategy, but in the 2018 strategy, the document states that in the majority of cases, our representations will be private. I was wondering if you could talk about whether in the updating of the strategy, I guess that's still an accurate way to summarise the approach, and why it's important to have the balance between public and private advocacy. And in the case that it is private, how is progress tracked, and how can Australians who are interested in this kind of feel confident to understand, how we're doing?
So we certainly work with families and with the individuals because their requirements, their desires in regard to their case is paramount in our thinking. We will provide them with advice. The private representations, that will be a decision made based sometimes on previous experience with cases in that particular country, or it may be that we have been in discussions with the lawyers, with our like-minded partners, or other people who have gone through similar cases in those countries to see what is the most successful form of representation. Look, where we have success, it's very easy to measure, but a lot of the cases, the fact that the last execution of which we are aware of Australian citizens overseas was in 2015, I think indicates that the processes we're following, combined with the work of my colleagues in their advocacy globally, has generated success. But we are also working with other groups who've had experience overseas to talk to them about whether, from their experience when they were detained overseas and come back, whether they have received sufficient advice from us, whether they feel that it's working, because it's a learning arrangement for us, and so we'll continue on that basis, learning as we go along, and if something we see is obviously not working, then we'll take a different tack, because it is very much a live process that we work through in advocating for our citizens.
Mm-hmm. Senator, did you also mean on our broader advocacy?
Yeah, more broadly as well, that would be useful.
Yes, absolutely. Thank you. And yes, we are refreshing the strategy. And actually, I would say that the civil society submissions to this inquiry are very useful for us just to make sure we are on track and we're taking on board all of those excellent objectives. I think for us, we always bear in mind our overall goal, which is concrete steps towards full abolition of the death penalty in each country. And so for each country, we'll always judge the best ways to meet that objective. So I think in our strategy, we will still have a sense of that it's a mix of public and private interventions. I would say sometimes we definitely think public statements is the way to go, is the way to get progress, to show a country the world is watching, to be very deliberate about that. And in other situations, we want to be empowering the voice of others rather than being an Australian voice. In terms of how we can track progress, I think for us, it's a part of it is working hand in hand with civil society. They'll see progress, we'll see progress, making sure we're aligned. We get obviously reports from our posts as to their work. I think people can also track very much what we're doing in the multilateral system, what we're saying in the universal periodic review process for individual countries, so that they can track our efforts and specifically how precise some of our recommendations are, that we very much know which lever we're pulling where, and obviously more broadly in the UN, our efforts. I would say that, being able to say, for example, today that we've made representations in 73 out of 85 countries, many multiple representations at multiple levels of government, being clear about the extent of our advocacy is going to be really important. But, Ambassador, did you have anything?
Thank you. Just 73 out of 85 is extraordinarily broad. How does the department determine allocation of resources in pursuit of abolition of the death penalty with that broad number, or that large number and kind of broad context in mind? And are there particular regions or countries that you particularly focus on, and do you have some insight into the strategic influences as to why you might approach it that way?
Thank you. We sort of have a twin track approach, I think we could say, to this. So we have a centre where the ambassador and I work, and we own the global strategy, we own the global approach. We are a centre for advice, for best practice, to workshop what approach might work in a country. We can see good practices across the world and see how we can apply them. But then really our advocacy on this is mainstreamed across the department, as you can see by how many people from the department have come here today and across our posts. So it's difficult to pinpoint the exact number of resources, because I think every officer at every post in a retentionist country thinks this is part of their work. So we wouldn't be able to add up the resources, but sort of to assure you there's a centre that sort of has an overall vision of what's happening in the world, and then officers across the globe have a bespoke approach. So that's how we allocate resources, if that makes sense. Just in terms of the communication and collaboration with civil society groups, what is your observation about the kind of level of resources and I guess effectiveness and how you work together, and whether or not, in terms of, like, I think you mentioned that there is very good collaboration and important work to be done together. What kind of pressures, and are there things that the Australian government can do to assist where there are pressures in that space, that where they do things that complement the work that you do, but you can't do yourself? Does that make sense? I think the ambassador works very closely with civil society, so I might get her to answer this.
Yes, thank you. Yes, I just emphasise first the really critical role of civil society in many human rights areas, but of course in the efforts to abolish the death penalty, it's it's so important, and they have a track record of really insightful, detailed, empirical work, which is absolutely vital for what we do. And I think, as you alluded to, some of that detailed research is something that DFAT certainly doesn't have the capacity to do. So our collaboration in terms of consultations is invaluable for us, but also we're very conscious that, I suppose, like many civil society groups, having various forms of funding support is really important for what they do. So we have, over the years, provided various amounts of funding support, mainly through, we have a human rights advocacy grants program. It's fairly small scale, but we have provided funding under that. And in the period about 2017 to 2024, I mentioned 2017 because that was in the lead up to our last strategy. In that period, we have overall provided about $1.5 million for various projects. Some of the detail of the particular work we've supported, some of it has some sensitivities because it goes back to this do no harm principle. But to give you a broad idea, we have funded essentially around research and analysis on application of the death penalty, including in relation to the disproportionate impact it can have on certain groups. We've funded work which goes to advice and legal representation in individual death penalty cases, which can be, again, critically important, including in our region. Projects that influence public and government opinions, again, a really important area of work around societal and other views. We also provided, in this period that I'm referring to, helping the establishment of the Anti-Death Penalty Institute, the Elios Justice Centre at Monash University, as a sort of coordinated regional hub. Also, we provided training and networking opportunities or funding for that for representatives, for pro-abolition civil society groups, support around publishing accurate data, some support to strengthen the capacity of national human rights institutions in our region to promote abolition of the death penalty. And also there has been some support over the years for some of the parliamentary campaigns for abolition of the death penalty. So, as I said, we do have more detail on some of the breakdowns of this, but in some cases some of the projects were fairly low-key or sort of kept under the radar, but it gives you a bit of an idea of some of the work. But it is, of course, for DFAT, it is overall constrained by what sort of budget we have available, but we certainly, in our human rights advocacy grants program, it has been quite a feature over the years.
Thank you. Do I have time for one more?
Thank you. I guess, of course.
Yeah. Just on data, so I understand there's information gaps in some countries. Has there been any progress in any of these countries, so China, Iran, Thailand, as examples, in increasing the level of reporting, or do you have any what strategies do you look to try and address that issue?
It's a good question, Senator, and I think each country some do have reporting, but they do it in different time frames or that suit their parliamentary calendar year, and so it is really tough. And this is where we really rely on civil society, to be honest. And so, the Amnesty statistics are often the Bible that we refer to on these numbers, because they have such a broad network on the ground. So I think data is a real weak spot for us. It means we can't ascertain the extent of the problem. We can't ascertain all of the vulnerabilities of certain groups within that data. And so we get as much as we can from our posts. We encourage governments to report, and we very much rely on civil society networks. In some cases, for example, families or individuals are very clear that they do not want this to be public. And so that makes data even harder to come across. So data is something that is very much on our mind, and we work hard to get. But civil society really there are just our biggest ally.
Thank you.
And the Chair has joined us by video conference. Chair, would you like to ask any questions?
Thank you. Look, I wanted to go to a question that asks if there are any emerging or known trends in terms of particular groups that are heightened risk of the death penalty. I ask that too because in my experience as a Member of Parliament, especially when we're dealing with immigration and protection visas, there are a large number of people who come to Australia seeking protection on the basis of persecution because of sexual orientation and other things. In your advocacy, how serious is that emerging group and how is it being dealt with, and how are we dealing with it in international forum or as part of our ongoing advocacy around the death penalty?
Thank you. Yes, this has long been part of our strategy to get as good an understanding as we can of the particular vulnerabilities of some groups to the death penalty, and it's a central component, has been and will continue to be, of our advocacy to draw attention to the fact that not only are we strongly fundamentally opposed to the death penalty, but in retentionist states, the fact that some groups of people are disproportionately affected is something that we try to draw attention to, gather more information on. The International Covenant on Civil and Political Rights specifically refers to people under 18 and pregnant women as people who should not be subject to the death penalty for those states which have not yet abolished it. But of course, as you mentioned, there are others. We do see and it's hard to track trends because these things tend to happen in the countries where the data is most difficult to get, but certainly vulnerabilities based on religious beliefs, based on political views, based on sexual orientation or gender identity are definitely issues that come up. And while there is not necessarily a clearly defined definition of most serious crimes for the death penalty, although there has been a general comment issued on that by the Human Rights Committee, and which not all states agree with, but there is some guidance that makes very clear that to the extent that any country retains the death penalty, it should not be applied for a person's belief or religious belief or other beliefs. Or it's very, very clear that serious crimes have to do with intentional killing, essentially. So where we see in cases like Iran or in other parts of the world, clearly people being... And also I should have added, it makes clear that it should not be used for drug-related crimes. So all these areas that we specifically lobby on in retentionist countries to say we oppose the death penalty entirely, but to the extent that you haven't abolished it yet, our clear view and our clear legal interpretation is that these are areas that should be should not be within the purview of what sentences which can carry the death penalty. We have seen more instances of discussion, even if not finalising in law, issues around the death penalty potentially applying to homosexuality. We're making very strong representations around those issues. So it is definitely something that we are, and our posts in these areas continue to get all the information they can about those trends and about those issues, and work very much to ensure that the most vulnerable groups are protected as far as possible, and that the fundamental illegality of that is also something that's made clear in our representations. But overall, yes, an area of concern that we're watching very carefully.
I guess I know you're referring to Uganda's recent legislation and the possibility and concern around some other African countries feeling the need to perhaps follow suit. How many countries in the world, I guess might be a stupid question, actually have in law, sexual orientation as attracting not only legality but attracting death penalty? I know the obvious ones, some of the obvious ones, but are there any others that...
There are still quite a number of countries, I'll take on notice the exact number, that criminalise homosexuality, and some countries where it's criminalised but not in practice. It's criminalised in law but not in practice. In terms of homosexuality being punishable by the death penalty, there are still a small number of countries that have it, including Brunei, for example. There are quite a few countries though where it hasn't ever been enacted. So it's
and
more.
It still exists.
It still exists, exactly. So that's something. And we are also working. You may be aware on an LGBTQIA plus international human rights engagement strategy, which is also well advanced. And these issues are very much the decriminalisation component of that is a big part of what we're doing.
Have you started your engagement with that issue and in relation to the death penalty? Is that something that you're also that advocacy a part of what you do now?
Absolutely. In terms of non-discrimination and equality around LGBTQIA plus rights. Absolutely. And where there's been, as you say, where there's been some references in some contexts in Uganda and then in Iraq, there was also discussion early this year of the death penalty being the sentence for homosexuality, which didn't end up in the law, but we did as soon as any discussion appears around these issues. So in a way, not to diminish our attention, our focus on those countries which still hold may carry the death penalty for homosexuality. That is still part of our work, but where it hasn't been, of course the objective is to decriminalise and to remove that. But I think some of the most worrying contemporary trends have been things we've seen in the last 12 to 18 months, which have definitely been the focus of some of our work to try to prevent that going in that direction.
Now, some of the laws that are obviously shaped or influenced by attitudes in these countries in particular that I'm thinking of, religion seems to be a reason for why certain practices are considered to be, therefore illegal and punishable. I know you act in the diplomatic sphere, but has there ever been contemplated, or is there any possibilities of discussions with religious figures in relation to, starting a dialogue around attitudes to groups that they feel, or pressure governments to declare illegal and, to warrant the harshest of penalties?
Absolutely. That's a really interesting question, interesting issue, because where some progress has been possible, the role of the church in the societies you're referring to has been absolutely critical. And it's something that, again, as we draw lessons from civil society engagement, where we see, I suppose, more progressive attitudes or church religious figures who've been influential in their societies, it's absolutely a critical part of the progress that's been made, and including in the South Pacific region, some of the progress that's been made and some of the discussions could not be possible without discussion of engaging the churches. Now that has challenges in itself because, as you say, there will be elements within some church groups which are very conservative and very, very firm views and are very influential. But without that component in many of these contexts, you cannot make progress. So it's definitely part of it. Again, often in incremental, quieter ways, because the last thing you want in these discussions is often for these things to be seen to be externally driven. These are locally owned progress, and I think that's another in this whole debate in this sphere that you're talking about. One of the things that in some Pacific Island countries are doing very encouraging work on reclaiming what are centuries-old traditions of inclusion and tolerance, so that whereas some that might argue in some countries we're seeing, these sort of Western constructs being imposed, you have countries saying that's nonsense. We have centuries-old traditions of inclusion and tolerance, which is really what underpins progress where it's possible on these issues. So that's what we're trying to help encourage and enable where we can.
I agree with the South Pacific has been engagement with churches has been critical for a whole series of other issues as well. But I'm just wondering, have we got any engagement in Africa at all in relation? And I can ask, do we have any engagement in Uganda? I don't know what the answer to that will be, but have we focused on Africa at all? around these issues, which are sensitive issues. And
Yes.
given our nuanced and I think, expertly nuanced diplomacy on these issues, we might be one of the countries that are better placed to have these approaches.
Thanks, Chair. Gemma Huggins, Assistant Secretary, Middle East Branch, but I'm here actually representing the entire Middle East and Africa debate.
And the Middle East as well, I'll include that. Yep.
I guess in relation to Uganda, obviously it's been an advocacy priority for Post, and they've made a number of representations this year. Our Assistant Foreign Minister also tweeted our concern about the Anti-Homosexuality Act, urging Uganda to respect human dignity and provide equal opportunity to protection to all under their laws, and obviously highlighting the fact that the Act is a shocking reversal of human rights and a grave threat to lives. So I think that our High Commissioner there regularly discusses it with the government. I think it's an issue also raised across the Middle East as well. In relation to the Gulf states, we have regular discussions on human rights regarding this issue. Obviously, the religious nature of some of these states make them non-receptive to some of these discussions, but we do make the point around our own values and principles when it comes to this issue.
I would say also, Chair, that I think in all of our countries, our diplomats will assess which groups will be the most influential, and often it is religious groups. And really part of it is then just to start the discussion to understand the perspective of that religious organisation. What's their perspective towards the death penalty? And can there be a dialogue with them, perhaps, on the facts and the figures? So it's really, even if they're not in the end, if they're not going to be the ones who drive change, so that we understand their perspective and therefore can think about how we approach that country is incredibly important. So dialogue with religious leaders in all of these countries will underpin all of our work on this.
My other question in relation to this again is, are there other like-minded countries like us? And I'm thinking of Canada now in relation to Uganda, where I think they had indicated they didn't want to be involved. They weren't going to deal with Uganda within the CPA conference. Forgive me if I got that wrong, but I think they were wanting to take some action, which was different to our thinking around this issue. How do we compare to, how does our approach compare to other like-minded countries?
I might just say a couple of things, but
Sure.
You are right. We have a very strong group of like-minded countries that we work with on this. We have groups of friends in different countries. Our diplomats will get together and coordinate very closely. Sometimes it's useful to have a coordinated approach, and so we will jointly démarche countries. Other occasions, that is not the best way to go forward. And so actually, it's not a sort of gang up scenario. And actually having those of us being coordinated but not having an identical approach can actually be quite helpful. Sometimes we divide up effort, for example, that, one country can focus on one aspect of influence and one on another, and so together we can be stronger. So I don't know if Bronte has anything on the Uganda example, but even if you don't see us saying the same thing at the same time, we will always have a coordinated approach behind it.
And I would just add to that, often the approach we take, or very often, is informed, at least in part, if not largely, by advice from civil society, either here in Australia through our networks or on the ground in the country, because they're really well placed to give advice on what will or won't have the most impact or be detrimental. So that's another. The like-minded coordination is very strong, and then the advice, the local advice on the ground, which we depend so heavily on, about will a certain approach backfire, will it fuel the more conservative voices or not. All those things get taken into account. But it can mean that then from what people see from the outside, it's sometimes maybe that behind-the-scenes work is not always as clear.
I've got one final question because I do want to give the Deputy Chair his opportunity as well. Just in relation to our bilateral diplomacy and advocacy, do you see opportunities for us to use economic and trade agreements as vehicles for advocacy against the death penalty. I mean, it's a big question. You don't, but I'm just wondering whether we do that at all, or whether there's any value in that.
It's an interesting question, Chair, and I don't think we've necessarily thought that through. What I would say, though, is that in terms of economic and trade outcomes, and it is really good to think about with a country, what do you share? Always approaching a country not with what are your differences, but what do you share? What values do you share? What outcomes do you share? Development, economic, trade. And so how can we couch our arguments in those terms on what we share, not what makes us different? So I don't have an answer on using specific agreements, but I would say in terms of thinking big, thinking broad, identifying new areas of commonality, and then finding a path that includes human rights to get to that point of commonality, that is an important part of our thinking very much.
Thank you.
Thank you. What is the time frame around the finalisation and release of the updated whole-of-government strategy?
To be very honest, Senator, we're sort of waiting for this inquiry, reading the submissions now. So we have a first draft very well advanced, and we will now be looking at the submissions and hearing your views, and then we hope to have it finalised very soon after that. So we have a very advanced draft.
And has the department done its own work in identifying strengths and weaknesses in the existing strategy? And can you share with the committee what strengths and weaknesses you might have identified already, having worked with and in the strategy for a period now?
Yes, I think I'll hand to the Ambassador in a sec, but I think the whole of government coordination aspect has been really important to us this time, just to make sure that it's all government agencies are on the same page, that we have a whole of government approach. The other thing I would say is that obviously the death penalty strategy is very general and very broad. So we've been thinking through how we match that with greater guidance to specific countries on best practices so that we can really help our posts. So we have a uniform global approach, but what more do our posts need really to strengthen their arm? So those are the sort of lessons that we've learned. Ambassador, do you want
I think that's right. I think, yes, the whole of government really cohesive coordination is very important. I think the very tailor-made evolving approaches within different countries it's really highlighted the importance of that. We can have broad strategies and broad guidelines, but what's going on in a given country at any given time, given the political evolutions there and societal views, is really important to be very attuned to. And I guess the other, in terms of weaknesses, really the ongoing challenge of the lack of data, the not always really knowing what's going on, which we don't really have a simple solution to, but it's just something that we will diligently continue to pursue, as we said again, in cooperation with CSOs to try to get the best information to inform that.
And maybe just two other things. I think one thing that we've learned very much is the risk management side of it. So before you go into a country, to think quite deeply about what effect you're trying to achieve, how best to do it, and how to mitigate risk in doing that. But also in terms of that, then the support that we need to give our ambassadors and our diplomats. So they all, all ambassadors will meet either myself or Bronte before they get deployed, and how can we really strengthen their arms? So that's been part of our thinking as we've reviewed the strategy.
So with the whole of government strategy, it sort of suggests that there might be some friction points or some points of tension in that whole of government approach. Have there been identified any points of tension or friction in how other departments or agencies might seek to advance Australia's abolitionist goals, but the tension arises because they might have a law enforcement objective?
I would say no at all. We haven't identified any frictions. It's a very, very strongly held outcome we're trying to achieve across government. I think the lesson was more learnt for DFAT about just making sure that we are very clear with our government colleagues what we are doing. And so it's more a coordination mechanism that they know exactly what we're doing on advocacies in different countries. And so whether they're working on cooperation programs or in law enforcement or whatever, we are very much aligned at the country level as well as at the global level. So absolutely no friction points, just a lesson learnt for DFAT to you can never communicate enough.
So we'll have the Australian Federal Police with us shortly, and the matter of mutual assistance in criminal matters. Is the department satisfied that the AFP arrangements and processes fully support our objective in regards to abolition of the death penalty and ensuring that Australians in particular, but other people, are not put in harm's way or put in a dangerous situation in regards to the death penalty?
I think we have no doubt about the AFP's approach to this and their commitment to this. Whether it's here in Canberra when we talk to them about it, or their offices around the world, they keep this in mind in every aspect of their work. That's very clear to us. So I would say no, we're very closely coordinated, and we definitely understand the intent in everything that they do.
So there's a high level of confidence that in other parts of the government, that high levels of awareness about Australia's objective in this regard.
Yes.
Yeah. Ambassador, you talked about the shrinking of the civil society. So we understand that initiatives that are homegrown in retentionist countries are likely to be more successful in advancing reform. But then we have a shrinking civil society, which would make it harder for those homegrown initiatives to take root. So how do we address that conundrum?
It is a big challenge, but I think part of the basis of how we approach it is that, and which is one of the rare points of encouragement, I guess, is that there are people, even in the countries where the statistics are horrific, we know there are people, whether they're in government or civil servants or civil society, who are not necessarily supportive of the death penalty. So it's how can we find ways to have the conversations to give voice directly or indirectly, however informal or so in some contexts we might not be talking about an organisation per se. We might be talking about one or two people who the embassy or the mission may have the opportunity to get to know through all their discussions, who is opposed to the death penalty and would like to work on it. So it's finding ways to identify those voices across the spectrum in different countries and find ways to best work with them. Again, coming back to the value of civil society here in Australia and in our region has a lot of those links. But yes, in some cases we're talking about very small numbers of people. We're not talking about big established structures or organisations because they're not allowed to. Those organisations can't register. If they tried to register, they would be, face various forms of repression. So it is about, which is a big part of integrating this work into the work of our missions across our overseas network, because they're best placed to come across to be able to identify those voices and opportunities and find the best ways to the extent possible to enable them.
Have we seen other countries adopt a similar operating style to Australia? Are other nations using a whole-of-government strategy when they're advocating for abolition, or is their approach more ad hoc or limited to their foreign affairs functions?
I think it varies a lot, but I think there are some who take a very whole of government. The countries that are active and dedicated in Switzerland.
I think the UK had a whole of government strategy as well, but it's certainly not. It's not a standard practice. I think ours is frankly quite a good practice example about how you can do this. Have a strong centre and then have a multi-pronged approach. I would just sit there on civil society. With the shrinking space, it's a really interesting challenge for us to be creative. So, for interested in the chair's question about are there business groups, for example, business leaders that we can talk to. So it means we need to be very broad in our thinking of influence.
The Capital Punishment Justice Project made two recommendations. Well, they made a number of recommendations, but two that stood out to me. The first was to amend sections of the Mutual Assistance in Criminal Matters Act and Extradition Act to remove the Attorney General's discretionary powers that allow sharing information in cases where the death penalty could be imposed. And secondly, to legislate against the AFP's sharing information with foreign law enforcement if it could result in a death penalty outcome. Does the department have any views on those? Is the department familiar with those points, and does the department have a view on the suitability or otherwise of those two initiatives?
We have read those recommendations, so we've definitely seen them. I think obviously questions best directed to colleagues from other government agencies that come after us. I think those recommendations aren't necessarily new, but I don't think DFAT has necessarily a view on them. We definitely would take our colleagues across government's view on that, noting that we are very clear on their intention here and that they are fully on board with what the Australian government is trying to achieve.
You talked in your opening statement about the successes and achievements in Malaysia and Ghana. Can they be, those successes, can they be directly related to the whole of government strategy?
I think I also said in my opening statement something that's so broad. So many things had to happen for those successes to happen. You know, the right time in Parliament, the right time with public opinion. So I think it would be very hard to pinpoint direct success. I would say, especially in the Ghana example, it was very encouraging for us, though, to think when you do what we said in the strategy, you work with like-minded partners, you work with civil society, you have a very clear approach over a long term about how you can influence change, and then you see a result like that. It's very encouraging for us, but I wouldn't want to in any way claim that Australia's actions led to that, because it is so many things have to happen for a good outcome like that.
And then finally from me, how effective are United Nations mechanisms? How effective is the Human Rights Council? How effective are the periodical review mechanisms in driving, recognising that much of this is incremental, but in driving change and reform?
I mean, I think we approach it in two different ways. First of all, I think for us it's very important to keep the general principles and keep moving the dial on the universality of those principles. So the general resolutions, even if we can't point to a direct effect, it is really important to keep those on the records. On UPR, actually, overall, there's quite a good success rate in terms of countries taking up UPR recommendations on the broad in human rights. It's been actually one of the most successful innovations in the human rights mechanisms for incremental progress. So if you make your recommendations very precise, where the country has to react to it and come back in 4 years and tell you how they've done, it is more effective than other UN mechanisms that we've seen. But we obviously can't tell you that has turned abolitionist countries, but it is a very detailed global focus on the world stage, where they have to come and explain how they will react to a specific recommendation progressing abolition.
Yeah, the only thing I'd add to that is I think while it's hard to pinpoint the specifics, I think having the resolutions, having the regular consistent raising and the universal periodic review process, it's really important to the broader messaging to promote a message that this is where the world is heading. So even though there's holdout states and resistance, it's still, in effect, we're trying to raise the level of discomfort from the holdout states with a sense that there is momentum here. And I think resolutions can be you know, some people might say, oh, it's just symbolic, but I think that symbolism in an issue like death penalty, because it can demonstrate this is a direction the world is going in, and you retentionist countries need to think about that. That's part of the objective. So it's well worth chipping away at.
Cause for optimism or caution when we think about progress towards global abolition of the death penalty?
I mean, Senator, I think the way I started, Amnesty International has found 144 countries abolitionist, and the number of countries carrying out executions, the number of countries being the lowest of record. So we cling to those moments of optimism and those numbers, even when you see it paired with the number being the highest ever. But in terms of cause of optimism, I think, you know, if you look at since we talked to the committee last in 2017, we can give you a huge range of countries that have moved either entirely become abolitionist in law and practice or have taken significant steps. So as the ambassador said, we like to say the global trend is clear. Just some are taking a little bit longer to come on board than we would like.
Excellent. Thank you. Great. Well, we thank very much officials from the Department of Foreign Affairs and Trade for their participation this morning. If you have been asked to provide any additional information, including questions or notice, please forward it to the Secretary by Friday the 27th of September 2024. And please note the responses to questions or notice will be published on the website as submissions to the inquiry. You will be sent a copy of the transcript of your evidence to assist you with answering questions taken on notice today, and you will have an opportunity to request questions to transcription errors. If I may, recognising the earlier advice around the sensitivity of the small numbers of Australians that are on death row, would the department be prepared to make those details available to the committee in a confidential submission?
Senator, can I take that one
Yes,
on notice? Simply, if we can, certainly very helpful, willing to assist. It may be that we go down into the detail of a country without the specifics of the individual. For clarification, no details of the individual or individuals concerned. Nation. 1, 2, 3, whatever. Yes.
That at that level, that would be enough.
Yeah. So I will come back to you on that.
And on a confidential submission, of course, it would not be not be publicly released or publicly reflected on here.
No.
Great.
Thank you very much for that.
Thank you very much. Yep. Great. Thank you, Ms. Robinson, and thank you, Ambassador.
Thank you very much. Thank you.
Well, that's a heavy burden for the committee now that that you'll be waiting for. A start. I now welcome officials from the Attorney General's Department and the Australian Federal Police to give evidence today. For the Hansard record, would you each please state your name and the capacity in which you appear before the committee today?
Good morning, Susie Williamson de Vries, Assistant Secretary, International Cooperation Unit in the Attorney General's Department.
Great, thank you.
Good morning, Senator. Kelly Mansfield, the Acting Commander, International Engagement from the AFP.
Thank you.
And Tom Sharp, Director of International Crime, Treaties and Policy Section in the Attorney General's Department.
Great, thank you all very much. This hearing is a legal proceeding of the Parliament. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to questions and discussion.
I thank the committee for the opportunity to provide evidence today. The Attorney General's Department is Australia's central authority for international crime cooperation matters, which includes extradition and the mutual assistance process. The Australian Federal Police is responsible for police-to-police cooperation with its foreign law enforcement counterparts, but for both our agencies, the death penalty is a key consideration in how we consider and provide cooperation in criminal matters. We cooperate with other countries, including those that retain the death penalty, to support criminal investigations and prosecutions, both in Australia and overseas. This cooperation is essential to efforts to combat serious transnational crime, including drug trafficking, money laundering, people smuggling, human trafficking and cybercrime. And these frameworks are also key to ensuring criminals, including violent and sexual offenders, cannot seek safe haven or avoid criminal justice processes. As we noted in our joint submission, a number of our key partner countries retain the death penalty, and our cooperation arrangements accord with the position on the death penalty and Australia's international obligations, including to not remove a person to another country where there is a real risk that that person may face the death penalty. This is reflected through a range of safeguards in our legislation and treaties with other countries, as well as our internal processes. We ensure that death penalty risks are identified and then mitigated, including through obtaining assurances. Where these risks cannot be appropriately mitigated, then we are unable to provide assistance. I just thought I'd briefly comment on our processes. I note that our joint submission sets out the relative legislative regimes, and I'll then provide some operational context and statistics. So our department has robust processes in place to identify and assess death penalty risks, including preliminary assessments of incoming requests and then undertaking comprehensive and standardised risk assessments. Where we receive a mutual assistance request, our assessment will always look beyond the surface of the request. We look at the risk posed to any individual, not just the alleged offender identified. And we'll also look at the specific criminal offences in the request to consider whether any of the information about any alleged conduct could support charges which attract the death penalty. And we keep these processes under regular review to ensure that they remain effective in practice. As our DFAT colleagues had alluded to, the death penalty arises quite infrequently in our international crime cooperation casework. If it assists, I'll now provide some figures to illustrate this. In the 2-year period from 2021 to 23, Australia received a total of 1,157 mutual assistance requests from our foreign partner countries. 300 of these requests were from retentionist countries, including countries that are otherwise abolitionist in practice. Of these 300 requests, only 11 were identified as relating to conduct that could potentially result in later charges for death penalty offences. The department went about seeking death penalty assurances from relevant partner countries in relation to 10 of those requests. The other matter was not progressed for other reasons. So in those 10 matters, in 4 matters, the foreign country did provide us with an acceptable assurance that the death penalty would not be imposed or carried out, and we then provided the assistance that was requested. In one matter, an acceptable assurance was provided, but we couldn't give them the evidence for other reasons. And in the remaining 5 matters, we were either unable to seek an appropriate assurance and we did not provide assistance, or we're still actively considering the matter. And then there's the extradition process. In the 2-year period from 2021 to 23, we either received or had on hand 64 extradition requests made by foreign countries. In that period, we surrendered 12 people to foreign countries following the extradition process. None of those surrenders involved death penalty offences. In the same period, 6 requests were withdrawn from our foreign partners, and none of those were withdrawn on the basis of death penalty issues. Overall, in the last 20 years, 3 individuals have been surrendered to a foreign country following the provision of an acceptable death penalty diplomatic assurance. So in summary, while death penalty risks arise infrequently in our department's context, we have robust processes to ensure these risks are identified, and where they do arise, we act with extreme care, and we will only provide assistance where the risk can be appropriately mitigated. The safeguards, both in our legislation as well as our robust procedures, have been really effective in practice in upholding Australia's position on the death penalty. We also our department administers the legal financial assistance schemes, which can help Australians facing the death penalty in an overseas country with the cost of their defence, and we're happy to provide you with some further information about these schemes. I'll now hand over to my colleague from the AFP.
Thank you, Susie. Likewise, thank you for the opportunity to appear before you this morning. The AFP welcomed the opportunity to contribute to the joint submission with the Attorney General's Department to the committee. As you are no doubt aware, the AFP engages in international crime cooperation to support criminal investigations and prosecutions, both domestically and overseas. This cooperation is essential to ensuring that criminals cannot escape justice by crossing international boundaries and for obtaining evidence that may be held in foreign jurisdictions. However, there are significant risks associated with this cooperation, particularly when dealing with countries that retain the death penalty. It is crucial that we address these risks to ensure that our cooperation aligns with our international obligations and ethical standards. Of the countries that retain the death penalty, there are several that are important partners to Australia and the AFP in terms of crime cooperation. The risk of death penalty arises infrequently in crime cooperation matters, but when it does, it is taken very seriously. In respect of our governance, the AFP's national guideline on international police-to-police assistance in death penalty situations was first authorised in November of 2011 and commenced in February of 2012. Since that time, it has been regularly reviewed and amended. On the 4th of May 2023, the AFP authorised the introduction of death penalty oversight by the Sensitive Investigations Oversight Board, or the SIOB. It's now chaired by our Deputy Commissioner National Security. Death penalty requests are deemed sensitive investigations, with the SIOB maintaining oversight. Deputy Commissioner International and Specialist Capabilities is the ultimate decision maker, authorising the release of information or provision of assistance to foreign law enforcement agencies in retentionist states. In conclusion, the AFP is committed to the integrity of our international crime cooperation efforts and, of course, upholding our commitment to human rights. Thank you.
Great, thank you, Mr Mansfield. Mr Sharp, do you have any?
No,
Great.
thank you.
Thanks very much. I'll invite the Chair to begin with some questions.
Yeah, thank you. I just wanted to go back to the initial statements from the AG's department in relation to figures and data. I don't think I caught the figures to the question that I'm about to ask, and that is, are there any instances where countries have agreed to but have not honoured undertakings from Australia not to seek to apply the death penalty?
Chair, we are not aware of any breach of any undertaking given by any foreign country in relation to the death penalty at any time.
You're not aware of any breach undertaken?
No, that's right, in relation to the death penalty, yes.
Right, okay. Is there a reason for that, or is it because you have good communications, or you can't, or...? I mean, as in we do not believe that there's ever been a breach. Okay. Certainly, yes. We work very closely with DFAT and the AFP in relevant countries, but certainly nothing has ever been brought to our attention that would indicate that a country has breached their assurance that they would not sentence or impose the death penalty on a person once we've provided assistance. Is there any possibilities that that could ever happen? And I wouldn't suggest that would be a failing on our part, but rather the perhaps less robust relationship with countries that we might be dealing with?
Certainly, while it's it's not an impossibility. We do a lot of front-end work before we accept an undertaking to ensure that it's appropriate and it is in the form, and certainly any contextual information about whether it's reasonable that we rely on that undertaking. So I'd say that the work is done up front.
I could just add to that to say it just generally it's a well-established practice. Other countries do it as well. We're certainly not aware in the broader context beyond just Australia of any instance of that happening. Obviously that would be hugely significant if it did occur, but certainly not aware of that.
Obviously, I get an impression that you have. We've got good working relationships with most countries. Are there any countries that where our relationship is not in the best shape and therefore would prevent us from being able to cooperate, either because an Australian citizen has found themselves in a situation in that country, or whether we need to send anyone back to that particular country who's here? Are there any countries you may wish to name that we would have difficulty having those sorts of frank and trustworthy exchanges?
Oh, Chair, I'm not sure if it's helpful to speak about specific countries. Certainly, we take our lead from DFAT and certainly their presence overseas and their views and guidance in how we should work with our counterparts. Certainly we maintain very close relationships with many key country central authorities who are usually ministries of law or ministries of justice or public prosecution agencies. But we're very much guided by Australia's broader presence in the country, including, of course, the AFP.
I understand. And obviously we are looking at the death penalty, and so since the 2015 inquiry, which was undertaken by a previous human rights subcommittee, what, if anything, has changed with regards to international crime cooperation with countries? I guess we're looking to see whether there's been any response to that committee's recommendations, whether there's been areas of improvement, whether there's anything that's still lacking or lagging, where might we be able to be of assistance going forward?
Sure, Chair. Maybe we can take you through the department's response to the recommendations in that inquiry. Certainly the department has implemented, the government accepted and the department has implemented those recommendations. As I mentioned in the opening statement, we're always reviewing our processes constantly, and my colleague in the AFP also mentioned regular reviews of the guidelines. We're always ensuring that they're fit for purpose. Sometimes that is in response to certain cases. Sometimes it's just regular review processes. One thing that we can say is that there is more international crime cooperation than ever before. Certainly the number of requests both that Australia is seeking in terms of evidence that is located offshore to assist investigations here, but also foreign countries identifying evidence here that may be of assistance is on an upward trend. So I think that indicates the transnational nature of many crimes that we have on our books. Tom, do you want to speak perhaps in more detail about what we did in response to the 2016 inquiry?
Happy to do so if that'll assist. So I think
Thank you.
From the previous inquiry report, there were 2 recommendations for the Attorney General's Department. So provided some high-level advice in the submission about what we've done. So the first related to reviewing our legislative arrangements for extradition and mutual assistance for consistency with Australia's obligations under the second optional protocol. And we can confirm that review did occur. We obtained advice internally from our Office of International Law about our obligations and consulted Department of Foreign Affairs and Trade. And the review ultimately found that our legislative arrangements are in fact consistent with Australia's obligation under the second optional protocol. But as Susie's mentioned, we keep our processes under regular review, both for consistency with our international obligations, but also Australia's broader position on the death penalty, and making sure that our internal processes for identifying death penalty risks, assessing those risks, and making sure that they're appropriately managed is a constant effort. The second recommendation that related to the department was in relation to legal financial assistance. I can speak to that now if that's helpful. And in particular, the scheme that's available to provide assistance in death penalty matters. I can advise that in relation to that, so one issue from the recommendation was in relation to retrospective costs. So generally the position under the broad guideline in relation to legal financial assistance is that retrospective costs, so costs incurred before an application is made, as a general position, such costs aren't eligible to be covered by legal financial assistance. With the exception being if, in sort of the most exceptional of circumstances, I think the terminology is, the department does consider that cases where a person is facing the death penalty will always fall into the circumstances of most exceptional circumstances. And the department does pay out costs that are incurred, particularly noting, I guess, the urgency that a person facing death penalty charges will need to seek legal representation. And our legal assistance branch is actually currently in the process of amending their guidelines to make that position clearer.
Thank you. Thank you, Chair. Deputy Chair.
Thanks.
Thank you very much. Just going to the statistics that you identified in regards to mutual assurance requests for 21 to 23, you identified 1,157, and then a subset of that was 300 requests from retentionist nations. What were the countries that were represented in that 300?
Deputy Chair, I don't have the exact casework figures before me, but I think as we identified in our submission, we have very strong, long-standing and robust country relationships with partner countries that retain the death penalty, including, for example, the United States, Singapore, Indonesia, India, Malaysia. So I would suggest that some of those countries would make up those statistics there.
Perhaps on notice you could just let us know that would be great.
We can do that.
What triggered the 4th of May 2023 review of the AFP guidelines?
The decision to implement the SIOB, the Sensitive Investigations Oversight Board, and then
elevate the decision making.
Yeah, and that's not restricted just to death penalty matters. That's all sensitive investigations. So that trigger point was identified as a requirement for the deputies and a quorum of assistant commissioners to have visibility and to be able to inject into those sensitive investigation matters. The decision was taken that all death penalty requests for assistance would be elevated to the SIOB, and that generated the change in the guideline. The guideline prior to that.
What was the motivation for that? So prior to the 4th of May 2023, death penalty matters did not get elevated to the Sensitive Investigation Oversight Board. So what was the motivation? What was the issue that forced that review and then forced the elevation of all death penalty matters to that higher authority?
It rested with the creation of the SIOB itself. That came out of a separate review, and when that was established, the decision was then taken for DP matters to also be given visibility at the SIOB. Yeah.
So the Sensitive Investigations Oversight Board, how does that work? Does that meet as required? Does it meet on a regularly scheduled meeting?
Yeah, it can meet at short notice and consider out of sessions, but the whole point of the SIOB is to induce thought and debate at that experienced and executive level. The 3 operational deputy commissioners sit in the SIOB, as well as a quorum of assistant commissioners. If one is called at short notice, for instance, you're not going to be able to get every assistant commissioner in the AFP into that meeting.
Are there any external bodies or agencies represented on the PSYOP?
No, there are not.
Right. And a decision that is taken by the PSYOP goes where? To the Attorney-General? To a higher authority?
No. The AFP, operating as an independent statutory body, makes that decision, and that decision in respect of sharing the proposed information or assistance is made at that level, and that's the enabler to indeed share that information.
It's a heavy burden to carry if there's a death penalty consideration.
Indeed.
And am I right to assume that thus far there has been no death penalty consideration put before the PSYOP?
No, there have been. I have got some statistics here. I think
Who chairs the PSYOP?
The Deputy Commissioner of National Security chairs the PSYOP, but in respect of death penalty requests, the final decision maker is the Deputy Commissioner International and Specialist Capabilities.
Right.
There were three matters that went before the PSYOP since May 2023.
So since May 2023?
Yes.
So just over 12 months,
Yes.
the PSYOP has considered 3 death penalty matters.
4 in total, but 1 was for post-arrest assistance. So whilst that matter went through the PSYOP process, the ultimate decision maker in that matter, being post-arrest, is the Minister. The PSYOP process was activated, informed the ministerial brief that went to the Attorney-General for decision.
So, excuse my ignorance, but I do come from a policing family, but I'm not a policeman.
Yes, yeah.
So, just explain, post-arrest, how the context of that is different from the other 3.
Yes.
And are you able, at a high level, to give us a sense of what was the nature or characteristic of those other 3?
Yes. In respect of pre and post-arrest, there's been long-standing practice within our agency around where decision-making rests in respect of providing assistance in a potential death penalty situation. Pre-arrest, or certainly pre-conviction or pre-trial, that decision rests with the AFP. But post-detention, post-arrest, or any subsequent criminal justice process, any request to share information or provide assistance must go to the attorney. In respect of the 3 matters that went to the PSYOP, all were approved, and they all related to narcotics trafficking. The 4th matter that went to the attorney what was a terrorism matter.
Right. Am I right to assume that in those 3 that were narcotics related, they related to the same country?
No, it's 3 separate countries.
3 separate countries.
Yeah, I'm happy to provide those.
Okay, that would be great, yeah.
The Philippines, Vietnam and Laos.
Right, okay. Who conducts the reviews? So we had a 2018 review of the AAP guidelines, 2021 review. So who undertakes the review? Who is the reviewer?
I might take that on notice, please, Senator. Yeah.
I'm just curious to know: is it an internal? Is it an internal person? Is it someone that has an association or a familiarisation with AFP processes,
Yes.
or is it someone external to the organisation?
Yeah, I'd be minded to say it's internal with assistance as necessary, and if that may be a previous member. Or it might be someone completely external, but please, I'll take that on notice.
So how does the AFP manage its police-to-police relationships and liaison with policing forces that have a very tight association to military regimes or authoritarian regimes. Of course, in Australia, we're very, very clear distinction between civilian authority and accountability over policing matters, but and I think of Myanmar in particular.
Yes.
How does the AFP navigate and trust that the policing force is not being used as an extension of the political regime?
Yes.
And therefore the political regime might be seeking to set people up, etc.
Yeah. It's
How do you
a difficult and
navigate that?
delicate matter, and specifically in respect of Myanmar, in the context of the broader threat that Myanmar has posed pre and post coup. Specifically
in terms of as a channel or a pathway for narcotics
for
to
narcotics
that's
trafficking.
right. Yeah.
Yes, specifically methamphetamine, less so heroin, but chiefly methamphetamine. Australia is the only country that maintains a law enforcement presence in Myanmar, and that was the case before the coup and certainly thereafter. So the relationship is long-standing with members of the Myanmar police force. There's levels of trust that come with relationships that exist over time, informed by other intelligence that's not necessarily law enforcement related, guides our officers at post as to the levels with which they can engage.
Again, it's a very heavy burden for whoever must be the AFP official in Myanmar.
Yes. But indeed, the expectation is not on them to think and act alone. There is, under the international engagement area, a degree of support that is able to be provided from headquarters, as well as the Assistant Commissioner for our international engagement, and then above that, the deputies and, of course, the SIL process.
In one of the submissions, there's a suggestion to amend the Mutual Assistance in Criminal Matters Act and Extradition Act to remove the Attorney General's discretionary powers that allow sharing of information in cases where the death penalty could be imposed, and a second proposition to legislate against the AFP sharing information with foreign law enforcement if it could result in a death penalty outcome. Does the AFP or the Attorney General's Department have a view on those two propositions?
Deputy Chair, maybe I can start with extradition and mutual assistance. To be clear, for extradition, the legislation does not give the Attorney General the discretion. The legislation provides that where a foreign country seeks to extradite a person from Australia for a death penalty offence, we can only extradite the person if the Attorney General is satisfied that either the person will not be tried for the death penalty offence, or if they are tried, that the death penalty will not be either imposed or carried out. So that is where those diplomatic assurances or undertakings come into play. They must be credible and reliable, and as Tom has said, it's very well established and accepted international practice. So absolutely, the Extradition Act does not have a discretion to send a person to a foreign country to face the death penalty. In the mutual assistance context, let me just take you through the two provisions that relate to the death penalty. And Deputy Chair, you also asked this question of the AFP in terms of investigative stages. One of the provisions anticipates that an investigation is at a later stage, so a person has been identified and arrested or charged and is before the court, so we're really at the pointy end towards a prosecution. And the other, which is section 8(1)(b), is at the early evidence gathering phase of an investigation where offenders may or may not have been identified at all and certainly haven't been arrested, and in fact there's lots of gaps, I guess, in information about what has gone on in terms of the crime. I guess the text of the provisions and the very limited discretion reflects this difference, and the information that may be available to us in considering the request to identify and also mitigate risks relating to the death penalty. Certainly both provisions are consistent with our international law obligations and our long-standing position on the death penalty. But if an amendment was made and there was only one mandatory ground of refusal, certainly in the mutual assistance process this would practically limit our ability to cooperate in cases where risks of the death penalty could otherwise be effectively mitigated. It could jeopardise our ability to cooperate with partners to respond to serious criminal activity, and it could have adverse implications for Australia from both a law enforcement perspective and at a diplomatic level. As we've said throughout, we act with a really high degree of caution in considering any request from any retentionist country, and in practice, if there was any identified risk of death penalty, we would seek an assurance before progressing to the Attorney-General for consideration.
I hope that assists. Before I go to others, how is the assurance provided?
Usually it will, if it's not part of the request that comes to us from the Foreign Ministry, it would otherwise be provided separately under a third-person note via diplomatic channels. So it either comes from our direct counterparts or from Foreign Affairs ministries, but always direct from executive government to our executive government.
And always in written form?
Written form, absolutely.
And is there ever an audit or a mechanism employed to make sure that those assurances have been actually upheld, or do we wait to hear that they have not been upheld?
It depends on the circumstances. Certainly in extradition that relates to the movement of a person overseas, if that person's an Australian citizen and if they elect to receive consular assistance, certainly DFAT in the foreign country would be keeping a very close eye on their prosecution. Otherwise, in extradition cases, certainly the court proceedings occur in the open, so information can be obtained about what the outcome is. And then, of course, in mutual assistance, noting the AFP's expansive international network, again, it's not unforeseeable that we could track the progress of certain significant investigations either.
In the 3 reports that have been done since 2018, I think 2018 or 2016, 2018, have all of the recommendations been accepted from those reports?
Sorry, Deputy Chair, what reports?
So at paragraph 33, it says the AFP national guidelines are regularly reviewed and updated. The 3 internal AFP reviews since 2018, which resulted in amendments and refinements, and then the following paragraphs, just at a very high level, go and identify what those AFP reviews had proposed. So my question is, were all the recommendations contained in those reviews accepted? Secondly, is it possible for the committee to see those reports, if necessary, reviews, if necessary, confidentially? And yep, there were the 2 questions.
Okay.
Yep.
I think that one.
Yeah, and I think, Senator, I'll have to take that on notice.
Okay. Yeah.
Please.
Okay. Yep. So the question is, the first question is, how many recommendations, and were they all accepted? And if possible, can the committee see those 3 reviews on a confidential basis? Okay, Senator Lemon, and then I'll go to Senator Reynolds. Yeah.
Just following on the guideline reviews, do you envisage that there will be another one post this inquiry in terms of anything that might be relevant that comes out of this?
Certainly, if there is anything relevant that comes out of this process, then yes.
Okay. Just a kind of more general, I think, process question for Attorney Generals. You talked in your introduction about assistance to Australians who are on death row. Could you just talk a bit more detail about what that looks like? And also, is the Attorney General's Department informed by the country of the particular individual who might need assistance, or does it come from the individual needing to reach out to receive consular assistance? Like, how does the attention come to Australia for the assistance?
It would usually be the individual reaching out, but of course, because if they are seeking consular assistance through DFAT, it may be DFAT that, and actually I think our colleagues made mention of the fact that they would talk through legal assistance mechanisms as part of the issues that they would discuss in their interactions. It could be a variety of ways, but certainly we would not expect that approach from our foreign partners. Just some general information about Commonwealth legal financial assistance schemes. So I think Tom had mentioned there is a specific scheme for overseas criminal matters involving the death penalty. Individuals can apply for legal financial assistance where they are being or will be prosecuted for an offence that may be punished by the death penalty and they have a continuing connection to Australia. So it's not limited only to Australian citizens, it's people that have a connection to the Australian community. Assistance will generally not be granted to people who can meet their legal costs without incurring serious financial difficulty. So there is some assessment of their ability to meet the costs. I think Tom has already addressed the issue of retrospective costs. So again, those circumstances are seen as exceptional, and the department is updating guidelines to make sure that's really clear in publicly available information. In terms of the speed at which legal assistance can be made available, we note that the department has a really keen awareness of the difficult circumstances that individuals in this position are in. For initial grants in urgent circumstances, we do generally adopt an approach of relying on kind of the absolute base minimum information available to support decision making. Of course, it needs to still accord with Commonwealth guidelines for legal financial assistance to ensure that the circumstances justify the provision of assistance, but certainly payments can be made quickly if they need to be.
Thank you. My other questions were all covered, so I'm told. Thank you.
Senator Linda.
So I missed the first bit, so my apologies. That was my first question, was actually about legal assistance and who pays. So I think that's all, except one part of it in relation to when you said connection to Australia. Is that somebody who has to have a permanent visa, or someone could be here on a tourist visa and have connections, family members here, or how do you actually define that?
It's not, I don't believe it's defined in our guidelines. I think it would be assessed on the circumstances of the matter, okay. But certainly it would include where people have direct family members in the Australian community, or where they have lived in the Australian community for a long time, whatever their immigration status.
Okay, so you'd expect, so either they'd have strong family ties here, even if they were resident in the nation that was prosecuting them, or in a third country. So you'd take that on a case-by-case basis.
Absolutely, yeah. I think it wouldn't be useful to be too prescriptive.
You may have already answered this question, so if it's been asked, not a problem, but just from both of your perspectives, what are the things that you think could be improved? So in terms of what are some of the things in process or things that we could look at that could be improved that would actually help you both? Now, whether it's what you just discussed with Senator Smith, Mr Mansfield, about some of the challenges for individuals in other countries who have to deal with mutual assistance delicacies or procedure, are there things that you think could be process improved?
Perhaps if I may be so bold...
Be bold. We like boldness.
A large proportion of our work and medium to high-end work is international. And those processes, whilst we have become quite accustomed to using them over the decades for which they've been in existence, they are frustrating for investigators. The processes around the framework of mutual assistance is inherently slow, and the more work that we are doing with international partners, the more pressure that gets put on our posts, our investigators, and our counterparts at the Attorney General's Department. And that pressure ultimately builds to stress. That at a high level is probably the leading observation. If there were mechanisms as a result of this process that could be observed and implemented that go to reducing the process requirements in order for us to act with a little bit more speed, would certainly reap benefits in respect of Australian investigations, but similarly for countries that make requests of Australia. When delays of years get injected into that process, that leads to frustration, which can obviously be elevated to ministerial dialogue in a broader sense. So, the process is the process, but should we just accept it for what it is, or should we look at ways to make it more efficient?
Thanks, Mr. Mansfield, thank you. So can we just unpack that a bit further? So are these mainly, and I've seen some of them myself over the years, so I know, again, just how frustrating they've been, not just for the individual officers and, non-uniformed staff, but the families and other people, or people you're dealing with who then express frustration to your people, particularly with long time delays. So are these frustrations, or these suboptimal processes, so we describe them, are they mainly on the Australian side, or are they compounded because they're not in sync with the many other nations that you're working in and dealing with? Can you just unpack those a bit more? Are they in the Acts? Are they in regulations? And are there ways, or perhaps even on notice, what are some of the improvements that could be made to the Act regulations practice process that could actually still have integrity but get rid of some of the dumb stuff?
Yeah.
So it's not technical term. There's always dumb stuff in the process.
We spoke earlier about the fact our respective agencies keep our own internal processes under constant review, and there have been a number of reviews in recent years. And I think some of the delays just are partly due to the trend that we noted, which is that we're increasingly needing to seek and also provide evidence to and from Australia in recognition of increasing transnational nature of crime. So some of them potentially are unavoidable. I guess it's just an open discussion about where we recognise improvements, working towards streamlining while maintaining safeguards.
Some of them, I accept that, but no system is perfect, and particularly when you've got different agencies and departments who, you've got DFAT yourself, you've got the AFP. Are there improvements, Mr. Mansfield, between, so not just internally within the three stovepipes, but also sort of cross? I mean, I know you do work very well together, but maybe if you could take that on notice. And again, it's not a criticism, it's actually one of the things we want to look at. How can we actually improve? What are the things that we could recommend that could help?
Great, thank you, Senator. We should also note our DFAT colleagues spoke about the strategy refresh, and certainly both of our agencies have been very closely involved and consulted in that process that's currently before government.
Thank you. Thanks, Chair.
Thank you very much. Has the existence of a whole of government strategy assisted the AFP in fulfilling Australia's international commitment to abolition of the death penalty?
Senator, I think it certainly elevated the level of awareness with our officers. To go back to the Bali Nine, I think that the level of understanding around the guideline that was in place at that time across the AFP was probably at a much lower level. I think those deployed offshore would definitely have had awareness of it, but the general investigator cadre probably didn't have it at the front of their minds. I think that's very, very different now. It's incorporated into our detective training. Any member that goes offshore as part of their pre-deployment processes gets a briefing on this. That decision-making in that international environment is very much something that's front of mind with the persons that we deploy offshore. And I think that's reflected in just a much better understanding and appreciation of the AFP's role against the government's position in respect of international crime cooperation, but of course the human rights aspects that we abide by from government.
But you're also saying that the increase in international policing and the expectations that you and your cooperative partners have means that whatever arrangements are in place or are required need to be the most, when I say effective, they mean the most efficient, so as to not so while respecting Australia's position, not to impede in the execution of your policing and investigation task.
Yes.
That's the tension, that's the balance.
It can be, Senator, here, especially if it's a time-sensitive or a time-pressured investigation. That can add additional pressure.
We can't control others, but where in our mutual assurance process is the delay? What is the step in the process or steps in the process that might be unnecessary, recognising that our commitment is non-negotiable? What are the steps in the process that are unnecessary, could be streamlined? I'm sure it's not the case, but if part of the process is sending a letter to someone as opposed to sending an email, you know what I'm saying? Where can those efficiencies be achieved without compromising or watering down Australia's clear commitment to abolition? Anyway, perhaps that's something for you to think about.
Yeah. Perhaps if I can just revert back to the previous question, I don't think it's just in the minds of AFP members as a front of mind position. Our partners are very well aware of Australian position as well. Whether it's China, Vietnam, Myanmar, Philippines, Malaysia, they are all very aware of the Australian government position on death penalty matters, and in some cases the inability, which will extend from that, in the AFP's ability to work with them, to cooperate with them, to give them assistance.
So they might make are you saying that they might make a judgment that they can't progress a matter any further because of our position, right?
Yeah. Or they may choose to work with another partner.
Absolutely, Deputy Chair. I think, again, our DFAT colleagues spoke about their very purposeful advocacy around abolition of the death penalty, but between our agencies and particularly the AFP on the ground. But we have, multiple times daily contact with our foreign counterparts as well. We are we're informally advocating for the abolition of the death penalty. We're making it really clear what the guardrails are around our ability to assist with reference to real live cases. So in some ways I think that is really powerful and certainly something that officers posted offshore take very seriously as well.
In terms of a possible efficiency, an ability to seek assurances early or earlier, that could be one option. But of course, that can only be a request from Australia. Whether the country that we make the request to would agree to that or not is entirely a matter for them. But that kind of assurance at the outset or early on in an investigation would be quite effective in removing delays associated with considerations around the DP, because they typically change. If it's a medium to long-term investigation, the risk at the beginning might be non-existent. It might emerge and be classified as low, and then it might track towards being a higher risk. So that triggers review by the SIAB. It's not just it goes to the SIAB once and then a decision is made. If the circumstances change, then the SIAB is reactivated.
So in the mutual assurance process, are you saying that issues around the death penalty need to be canvassed much earlier? And is that a process change that you're in control of at the AFP?
Certainly not at the AFP. So we would be the benefactors, but it's
and it has some nuance actually, because of course at the earlier stage it's a police investigation, and police may or may not be empowered in their within their government to provide such an undertaking. As we said, the actual undertaking that we would rely on before formally releasing any evidence is from the executive government, but again, that's potentially something that could be explored further.
And just a last question from me: in the data that you provided at the beginning of the of this hearing, you identified 10 mutual assurance matters. What were the nations that they that gave rise to those?
Oh, sure. Senator, I don't have that detail with me, but we can provide that on notice. Yeah.
Thank you very much. Are there any other... Mr Zapier, do you have any questions of the Australian Federal...
I don't, but I thought I'd just pop in. I'm sorry, I've been chairing another committee next door, so... Chair, are you still on the line at the moment?
I am, yes.
Oh,
no,
great.
I don't have any further questions. Thank you.
Okay, Senator Reynolds, all good? Okay, well, we thank the Australian Federal Police for your various improvements to the matter over the years, and we've had private conversations about this, so I thank you very much for your cooperation and attention to these matters. So we thank you very much for your participation today. You have been asked to provide any additional information, including questions or notice. Please forward it to the Secretariat by Friday the 27th of September of 2024. Please note that responses to questions or notice will be published on the website as submissions to the inquiry, unless, of course, they are taken in confidence. You will be sent a copy of the transcript of your evidence to assist you with answering questions taken on notice today, and you will have an opportunity to request corrections to transcription errors. We thank you very much again for your participation. Thank you. Thank you. And can you hear us, Maria?
Yes, I can.
Great.
Thank you. Yes.
Excellent. Great. Thank you. Well, I now welcome Mrs. Finlay from the Australian Human Rights Commission to give evidence to the committee today. For the Hansard record, would you please state your name and the capacity in which you appear before the committee?
Thank you, Senator. My name's Lorraine Finlay. I'm the Australian Human Rights Commissioner and appearing on behalf of the Australian Human Rights Commission.
Welcome. This hearing is a legal proceeding of the Parliament. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to questions and discussion.
Well, thank you, Senator, and good morning to the committee. And I'd like to thank the Joint Standing Committee on Foreign Affairs, Defence and Trade for the invitation to give evidence at this public hearing and seek to make a brief opening statement to support the written submission the Commission has previously made. Within Australia, opposition to the death penalty has been long-standing and multi-partisan. With the last execution taking place in Australia almost 60 years ago, the death penalty being formally abolished in all Australian jurisdictions almost 40 years ago, and legislation prohibiting the reintroduction of the death penalty in Australia being passed by this Parliament almost 15 years ago, it's perhaps understandable for Australians to see this as a human rights issue that perhaps has reduced urgency or priority for Australia. That is not our view. The Australian Human Rights Commission strongly supports Australia's efforts to advocate for the worldwide abolition of the death penalty, and for this to continue to be a high priority for Australia for two reasons. The first being that the universal abolition of the death penalty remains a significant global human rights issue. But secondly, because Australia's continued global leadership with respect to this issue is strategically important. With respect to the first reason, our written submission outlines the current situation around the world where, despite the efforts of countries such as Australia to advocate for worldwide abolition, and despite progress that has been made, it's clear that progress on this issue is not linear, and that the global use of the death penalty in terms of the total number of executions occurring around the world has actually increased in recent times. Amnesty International have reported that there were 1,153 recorded executions in 16 countries in 2023, marking a 31% increase in the number of executions that occurred compared to the year before. This continues to be a core human rights issue, with the death penalty being an affront to human dignity and having no place in the modern world. In relation to the second reason, in our view, Australia's continued leadership on this issue is strategically significant, given that the list of retentionist countries around the world includes some of our key allies and regional neighbours. Whilst this does require an approach that strikes a principled but practical balance between advancing Australia's advocacy for the worldwide abolition of the death penalty, with understanding the importance of international police cooperation in combating transnational crime, which in itself has significant human rights implications, the key word in the phrasing that I've used is principled. Australia needs to be consistent in its opposition to the death penalty, and this needs to be reflected in our approach to mutual assistance requests and international police cooperation. We note in this regard the joint submission and evidence provided by the Attorney-General's Department and the Australian Federal Police, and recognise, of course, that Australia does have obligations when it comes to combating transnational crime and police cooperation, and indeed that these are important activities that have significant human rights impacts. We would, however, note particularly the written submission provided to this inquiry by the Law Council of Australia, which has canvassed the benefits of a specific review of the Mutual Assistance in Criminal Matters Act 1987 Commonwealth and the AFP guidelines to ensure both compliance with international law and consistency with Australia's opposition to the death penalty, both in theory and practice. We would endorse that approach, which is consistent with recommendations made by the Australian Human Rights Commission as far back as 2007 around tightening the Act in order to ensure stronger protections against the risks of a person being exposed to the death penalty in a third country as a result of assistance provided by Australia. We would also encourage consideration to be given to the operation of the AFP National Guidelines and the AFP Sensitive Investigations Oversight Board. I've listened this morning to the evidence that's been given by both the Department of Foreign Affairs and Trade, the Attorney-General's Department and the Australian Federal Police, and I'm encouraged by the evidence that was given around a clear commitment across government in practice to ensuring that Australia's opposition to the death penalty is reflected in all aspects of our activities. However, the Australian Human Rights Commission does believe that further scrutiny needs to be given to these processes in order to ensure that the human rights objectives that underpin, in particular, the existence of the board are being met, and that we continue to strengthen and refine our approach to ensure that the best operational outcomes are achieved in a principled way. Continuing to take a principled stand on the question of the death penalty will provide a tangible demonstration of Australia's commitment to human rights and the rule of law, promote international dialogue on human rights, and contribute to a more just and humane global society. A key step in this is prioritising the updating of Australia's strategy for abolition of the death penalty. We welcomed the evidence of the Department of Foreign Affairs and Trade given to this committee this morning that process is well advanced, but we would urge this committee to make recommendations around not only ensuring that the completion of that updated strategy is prioritised, but also that DFAT is appropriately resourced to ensure that the updated strategy can be effectively implemented. Thank you again for the opportunity to appear before the committee this morning, and we would welcome any questions that you may have.
Excellent. Thank you very much for your evidence. I might go to the chair.
Thank you. Thank you for that. Look, as I listened this morning and also heard you speak, Commissioner, what can you describe as special about Australia's leadership and therefore reputation in relation to our advocacy and how we might be best placed or better placed to continue this leadership, especially in countries that we have relationships with in our region and elsewhere? Is there anything about us that makes us a standout?
Well, thank you for the question, and I think there are numerous things that make Australia stand out. But what has really struck me from listening, particularly to the evidence this morning, but also in preparation for this hearing, is the comprehensive and sustained nature of Australia's approach in this area. And that's why the evidence that we give in terms of improvements that could be made, we should stress, aren't evidence in criticism of attempts that have been made so far. Australia is a leader around the world when it comes to this issue, but it's about ensuring that we continue to improve our efforts, that we learn from things that have been done, and that we constantly try to set that leadership standard across the world, because we are in a unique strategic position in terms of, as we mentioned in our opening statement, the position of Australia being key allies and neighbours with a number of countries that are retentionist countries that do give us both the opportunity to advance the arguments around the need for worldwide abolition, but do also, we recognise, create sensitivities for us in terms of ensuring that international police cooperation can still occur, and we are also meeting our obligations around transnational cooperation in that sense.
So in relation to our domestic advocacy and educating Australia's global efforts, I wanted to go to Australian communities and diasporas that live in Australia, become Australian, integrate and, begin to integrate into the Australian community and values and laws and so forth. Do you think that those communities, and I asked this question earlier on to DFAT, do you think that those communities can assist the work that the Human Rights Commission and others do when that advocacy is taking place with other countries, in this instance retentionist countries? How useful is that, and how important is that to Australia's currency and the value of its leadership?
Well, I think that is important, and I think that Australia should be using every possible approach that we can, both formal and informal, in terms of advancing our advocacy in this area. But I'd actually go one step further as well, and it's interesting, Chair, that you mentioned domestic advocacy, because I would refer you to paragraphs 13 to 15 of our written submission, where we speak about the importance of not only ensuring Australia's global advocacy on this issue, but also domestic advocacy to make sure that the Australian community understands the continuing importance of this issue, and in particular that future generations of Australians understand why the abolition of the death penalty was such an important step for Australia, so that there's no question we take for granted that that will be the case in perpetuity, but that we continue to educate young people about the importance of a full range of human rights issues, but in particular this one.
Well, on that very issue, and taking into consideration how one generation might, perceive the next generation, is it true that current younger generations of Australians may lack a certain history and awareness around, in this instance, the abolition of the death penalty in Australia and the advocacy around that, and therefore we need to elevate as you say, a wider awareness, raise awareness to our own people. And that would also, I assume, give us the opportunity to further raise awareness and education to our newer and emerging communities who are settling in Australia and who may be coming from retentionist countries that have particular views that are slightly different to ours. Do you think there's work to be done? Clearly there is. Well, I believe there is. But is there work to be done further, and how can we work together to ensure that a lot of our funding and of programs which go to social cohesion and multicultural policy also goes to the history and of issues such as capital punishment, that I'm sure people, if I ask my constituents about abolition of capital punishment in Australia, I don't think many of them would know whether they're young or old. So how much of an awareness campaign should we be thinking about seriously that could aid and we can leverage on in terms of our global leadership as well as our domestic?
Well, I think as a general proposition, there is always the risk that when a particular human rights advance has been the subject of such long-standing, widespread agreement, that it becomes taken for granted to a certain extent, and that there's a real need to ensure that we do continue to explain why this is important, why it matters, and why Australia needs to continue showing global leadership on this issue, both because that's important in terms of worldwide abolition, but also within Australia it's important to ensure that future generations of Australians, but also newly arrived Australians, as you mentioned, understand the history, why Australia's had that position and why it continues to be important to retain that. We say at the Human Rights Commission all the time in relation to human rights that obviously human rights are important, but we can never pretend that they're inevitable. There's always a need for education, both around general human rights issues and specific issues like this. And we would say there are many things we can do across government and across civil society to ensure that level of awareness and education. And certainly the Australian Human Rights Commission plays a significant role, and a core part of our mandate is providing that education and promoting awareness in Australia of these human rights issues.
So my understanding is that you would probably feel that a recommendation around increasing that awareness or certainly supporting it even stronger would be very useful to our domestic and global efforts in this space.
Indeed.
Yep.
Yes.
Can I just one other question? I think it was asked before, I'm not sure, it might have been the Deputy Chair, but we're leaders in this movement. Is there anything that other, and maybe even retentionist countries, might have views about us that might mitigate against the, the total currency of our position? How are we perceived by some of those countries? I think this question was asked before, but I'd like to ask you that, given that it is the Human Rights Commission. Is there anything that we should be aware of that could mitigate against our best performance?
Well, I think that would go to the earlier points that we made in my opening statement around the need to ensure that we're consistent and principled not only in theory but in practice, and that is ensuring that things like our mutual assistance and international police cooperation frameworks are robust in placing those human rights considerations at the fore. And in making that submission, again, I would highlight that's not intended to be a criticism of what's being done at the moment, but simply that we should always be mindful of wanting to ensure those processes are as effective as possible and that they're as principled as they can be in terms of showing consistency in Australia's position. And that's why we would support recommendations for reviews of those frameworks to make sure that they are well understood, that they are properly examined and that they are achieving those human rights objectives.
Thank you. Thank you, Deputy Chair.
Thank you very much. Senator Domainen.
In your opening statement, you referred to, I think, now correct me if I got this wrong, but referred to the DFAT objectives and processes, and I think you said that further scrutiny should be given to these processes to ensure objectives are being met. Mm-hmm. What would that look like in your opinion?
In particular for us, that referred to our suggestion that the mutual assistance legislation should be examined and the AFP national guidelines, and in particular the operation of the SIOP.
Okay, thank you. In your submission, you write that a key step in Australia continuing to effectively advocate for the universal abolition of the death penalty is the renewal and updating of the strategy for the abolition of the death penalty. And I think you talked about that in your introduction as well. What sort of changes do you think should be included in an updated version?
Well, I think that the key thing for us in relation to an updated strategy is actually ensuring effective implementation. So I think we're very cognizant of the fact that having a strategy is an important step, but if that strategy isn't able to be effectively implemented because it isn't appropriately resourced, then it's not going to achieve its objectives.
Thank you. According to Harm Reduction International, there was a significant global increase in executions for drug offences in particular last year. Do you know if countries that execute people for drug-related offences tend to experience the societal impact of drug addiction more acutely than other countries? And are there any discernible patterns, like an increase in illicit drugs being imported into countries or changes in socioeconomic factors that could be used to explain these increases?
I'm afraid I don't have any particular information or insights to offer you on that, Senator.
Okay, no worries. So do you have any comments then in terms of illicit drug use being seen as a societal and a public health issue rather than a criminal issue, that we would likely see less executions as a kind of a punishment for drug trafficking, do you think? So I'm thinking about like the approach of these countries, if they were to view it in a different way, and in which case, Australia might think about support, in an alternative fashion, if that makes sense. I don't know if you have any insights into that.
Well, certainly I think the approach of not seeing issues around drug use, drug importation, drug crimes as being purely a matter for the criminal justice system is one that's well supported in evidence and policy, and certainly from a human rights perspective, we note there are international obligations in relation to international drug trafficking, for example, and stopping illicit criminal activity around drug use. And there are also human rights obligations around things like the right to health and helping people to achieve positive outcomes in relation to achieving better health outcomes. That's something that should be part of an all-inclusive, encompassing policy around those areas. So certainly we would see policies towards drugs as not being exclusively dealt with through a criminal justice lens, but I wouldn't have any particular comments to make in terms of policies that other countries should adopt in that respect, because that wouldn't really be the role of the Australian Human Rights Commission.
Yeah, okay. And maybe just finally, sort of overall, I think noting that it sounds like additional resources is an area of focus. But how does the Human Rights Commission rate Australia's progress against the recommendations from the 2016 Joint Standing Committee report?
Well, again, we've seen the evidence that's been given in the written submissions that have been published, and note that there has been positive movement on a number of fronts, but we do say there is more work to do in terms of ensuring that those recommendations are fully implemented.
Yeah. And would you add anything else in terms of that more work to do other than what you've already said?
Other than what's in our written submission, that's really the core of what we'd like to see the focus being.
Yeah. Thank you.
Thank you very much for your evidence thus far. So when we think about retentionist states, some of them are some of them are very well advanced and would be regarded as, some of the most advanced and richest in the world, in the United States, for example. But if we were to think about where there might be opportunities for Australia's advocacy to take root more quickly and perhaps see success more easily, how important? So countries, coming out of authoritarian rule, countries where civil society organisations are starting to sort of flourish, is a human rights framework in those types of countries a prerequisite, do you think, in being able to successfully advocate for abolition if they are a retentionist state?
I wouldn't go so far as to say it's an essential prerequisite, but certainly we would say a human rights framework is generally useful in terms of the key arguments that are made in terms of the abolition of the death penalty. But I think the overarching point that you've really highlighted, Senator, is that when we look at the strategy Australia has in this regard, it really is context specific and about taking every opportunity through a variety of different levers to advance these arguments, whether that be done in a multilateral way or bilaterally, whether that be done privately or publicly. There are a variety of circumstances, and that's why that whole of government approach is so important, and that's why this strategy is so critical in terms of giving posts the opportunity who understand local context and are able to identify where those best opportunities may lay for progress in this area.
So am I right to assume that countries that are building human rights institutions, so prior to the coup in Myanmar, for example, a lot of discussion constructing a human rights type commission, is the Australian Human Rights Commission actively engaged in the building and sustaining of other like institutions around the world? And if so, to what extent are people interested in our position on the death penalty?
So the Australian Human Rights Commission is specifically engaged in a number of projects that are supported by DFAT to work with national human rights institutions in other countries or to work towards the introduction of national human rights institutions. And I'm thinking particularly of projects that we have in relation to Vietnam as one example. And those projects aren't specifically focused on the abolition of the death penalty, but what they do is apply a human rights framework and encourage, for example, the development of capacity, the development of reporting requirements, and the exchange of positions and ideas around developing human rights and a focus on human rights. So again, I think the work around the worldwide abolition of the death penalty, while a focus on that particular issue is important, when we look more broadly around providing for the improvement of human rights, the strengthening of national human rights institutions around the world, and a whole variety of interrelated issues, they all contribute to that end goal of creating a world that is more attuned to human rights considerations, more willing to comply with international human rights norms, and that will then hopefully also lead to a focus on this specific issue and progress on that front.
So the suggestion around more regular, well, you're reviewing the mutual assistance arrangements as well as the AFP guidelines, that has been suggested because it's not as if there's evidence that they are not working. It's more out of an abundant caution to make sure that they are as effective in meeting law enforcement requirements, but also upholding what I would consider a non-negotiable first principle around the death penalty as well. That's the motivation for that, isn't it?
That's correct. And also an awareness on our part that we don't have the operational experience or insights that, for example, the AFP do have. And so simply can't draw firm conclusions on the way that oversight is currently working because we don't have the information about how it has worked to date and whether it has been effective in that sense.
Does the Human Rights Commission have an idea about where might be the most fertile ground around the world to perhaps better focus Australia's limited resources?
Only through our discussions with the Department of Foreign Affairs and Trade, and in particular we did take note of the written submission they provided to this committee in terms of the work that they've done throughout the world and where some of those opportunities have arisen.
Would you consider the whole of government strategy to have been successful thus far?
Well, I certainly think you can see clear evidence of where Australia's advocacy on this issue has been influential and where Australia has taken that global leadership role, and that's something we consider to be very important.
Yeah, I accept that as well. I think it's very clear at the global level, and I think we wouldn't necessarily want to detail all of these, but I think there are quite powerful, more granular examples where our advocacy and has been very effective. Senator Reynolds.
Thank you. Lovely to see you again, Ms. Finlay. If you've covered this, sorry, I'm doing two hearings this morning. So to pick up Senator Smith's point about process, do you see that there's anything, either interagency processes and coordination, cooperation here and overseas, in a more practical way? Do you see any ways of improving that process or the engagement with you?
There aren't specific things that we would say need improvement because they're not working at the moment. Our evidence today is really about wanting to ensure that the focus on progress continues and that we're always looking for ways to continue strengthening and improving the role that Australia's playing.
So there's nothing in particular at the moment. If you could say, look, if we could, because obviously we've got the opportunity through this inquiry and report to suggest some further improvements. So there's nothing that, maybe you can take that on notice, and if there's anything that springs to mind after this.
Well, perhaps if I can answer that now, Senator, I can say the things that we have already mentioned in our written submission and we would highlight again are firstly the priority be given to the updated strategy, but importantly the resourcing of that strategy so that it can be effectively implemented. And then secondly, specific consideration being given to both the Mutual Legal Assistance Framework and the AFP guidelines and the operation of PSYOP to ensure that they are operating as effectively as possible.
Thank you. And if we come to your observations about almost civics, I'm doing another inquiry on civics, or the lack of civics education and training in Australia. So can you just explain for us what, in your submission, when you're talking about education in Australia, of the issue of death penalty abolition and increased advocacy for it, can you just unpack that a bit further about, if you haven't already done so? No?
Certainly.
Oh, sorry, thanks.
It starts from the proposition, Senator, that from the perspective of the Australian Human Rights Commission, human rights education is always critical because we can't take human rights for granted, and we need to ensure that the general population, but in particular younger generations coming through and newly arrived Australians, have a clear understanding of Australia's history in this regard, Australia's approach to human rights, and why a focus on human rights is something that's so critical. Australia's position in relation to the abolition of the death penalty is an important component of that, but not the sole component of that in terms of our view around human rights education. And it's not that we say there should be any one particular campaign run at one point in time. This is a continual process with a continued need to ensure that there is a focus at all levels of having a community in Australia that has a human rights focus and an understanding of what human rights mean.
Are you aware, I absolutely agree with you, but are you aware of any education system in Australia that is doing that?
We're aware of education systems in Australia that have elements of, for example, civics education or human rights case studies or examples throughout. However, we have, for example, made a submission to various inquiries both by this Parliament but also New South Wales springs to mind recently in terms of civics engagement and education syllabus, with our view being that there does need to be a greater focus not just on specific examples of human rights but on providing those broad foundations for young people in Australia and also for newly arrived Australians to make sure that the human rights landscape in Australia is well understood. Yes. And again, I made the comment before, Senator, that obviously human rights are incredibly important, but the need for education is because human rights aren't inevitable. Yes. So we need that constant focus to renew and strengthen our commitment and ensure that we can continue to progress our leadership on human rights around the world.
Would you mind providing the committee with the submission you did on that?
To both this Parliament and the New South Wales Parliament?
Yes.
Of course, Senator.
Thank you. That would be very interesting. Thank you.
Thank you. We heard evidence this morning about the shrinking of civil society and how that is impeding progress or a greater appreciation of human rights generally, but specifically around abolition of the death penalty. What sort of observations do you make about the shrinking of civil society beyond Australian shores, and how is that remedy? What is the remedy to that? What are the alternative ways to support civil society advocacy? Because one of the points that's been made is that homegrown initiatives around abolition are probably going to be much more powerful than sort of international advocacy or international. So do you have any observations about that?
Only that I would endorse what you're saying, Senator, and it is quite clear when you look at a wide variety of sources and evidence on this that there is real concern about shrinking civil space around the world. There are a variety of things that Australia can and should be doing in relation to this, but we would say the number one thing is leading by example, and that is ensuring that we have strong civil society engagement in Australia, that our national human rights institution is supported in the work that it's doing, and that we show not just through what we say but what we do that we believe civil society engagement to be a critical aspect of achieving better human rights in practice, but a fairer and more just society in total.
Yes. Any other observations you would like to make?
No, Senator, other than thank you for having us before the committee this morning, and we'd be happy to provide any additional information that you might need.
Right, well, we thank you very, very much for your submission and your evidence. I've lost my spot. So we thank you very, very much for your time today. If you have been asked to provide any additional information, including questions or notice, please forward it to the Secretariat by Friday the 27th of September 2024. And please note that responses to questions or notice will be published on the website as submissions to the inquiry. You will be sent a copy of the transcript of your evidence to assist you with answering questions taken on notice today, and you'll have an opportunity to request corrections to transcription errors. And again, we thank you very much for your participation, and I'd like to thank committee members and witnesses for their time today and declare this public hearing closed. Thank you.